Get ready. 5 seconds to go. Start. The trial court has also observed that the medical evidence with regard to the date of incident and the version of the prosecutrix in that regard differs. However, it has to be considered that the victim comes from Hamlet and has just passed 7th standard and was not expected to mention the correct month of the incident. So the defense had also contended before the trial court that there was no paternity test. So it was submitted that in the absence of such test, there cannot be any nexus of the accused with the pregnancy of the victim. So Dr. Joshi has examined the accused on 20th September 1996 and issued medical certificate exhibit 42 dated 26 September 1996. So it is not necessary to bring on record the evidence of paternity. So the testimony of the victim and other relevant and material evidence is sufficient to establish that the accused has committed intercourse with the victim, as a result of which she conceived and delivered a child. So there is no reason to disbelieve the version of victim with regard to the intercourse committed by the accused with her. Stop. Although it is expected that the FIR should be lodged promptly, however, on account of belated lodging of FIR in the facts and circumstances of the case, the prosecution case cannot be disbelieved. So it is necessary to note that after the intercourse under the pretext of marriage assurances and the intimidation, the victim was of tender age who did not disclose the fact of pregnancy from the accused, which was detected upon medical examination. Stop. It is required to be noted that in rape case there is feeling of reluctance to the police on accused of attitude of the society, and in such an eventuality there is any delay in lodging the complaint, the same is not fatal. Stop. Looking to the circumstances in the present case and the testimony of the victim, it will have to be held that delay has been properly explained. Stop. Merely because there is delay in lodging the FIR itself cannot be a ground to give benefit to the accused. Looking to the circumstances brought on record. Stop. The motive for false implication attributed by the defense cannot be accepted. Stop. The prosecution has established its case by cogent and satisfactory evidence that accused has committed sexual intercourse with the prosecutrix while she was minor. Stop. The accused had entered into the house of the victim and thereby committed the criminal trespass. Stop. The evidence of the prosecutrix was not settled during the cross-examination and she is consistent that the accused has committed rape on her. Stop. PW3 has deposed that on 12th September 1996 during the days of Ganpati festival he was called by